Welcome to my channel. Start. New Delhi. West Bengal on Wednesday walked the path taken by Union and Maharashtra governments to argue before a 9-judge Supreme Court bench that Article 39B of the Constitution should be interpreted to mean that material resources of the community would in certain circumstances include privately owned property to subserve the common good. Para. Senior advocate Rakesh Dwivedi, appearing for the Trinamool Congress government, argued before a bench of some judges that under the West Bengal Land Reforms Act, with its amendment, the state acquired vast tracts of privately held agricultural land and distributed it among landless farmers to ensure the mandate of the directive principles for distribution of material resources of the community to best subserve the common good. Para. The distribution may be piecemeal or kept in the control of a government agency or even a private agency so long as the benefits percolate through to the people as a common good. To illustrate, large privately owned ponds extending up to 500 acres can be acquired and put in control of a government agency or a cooperative society so that the pond is preserved so as to subserve the common good, Dwivedi argued. Para. Once the property is acquired, it indisputably becomes a material resource of the community. Upon acquisition, the private property vests in the state. All state property would be a material resource of the community, and upon acquisition, it must be distributed so as to subserve the common good, he added. The state's second counsel, Gopal, argued in the same vein but suddenly changed tack to ruffle feathers by questioning the validity of Supreme Court's 5-judge bench judgment, which by 3-2 or majority had last year declined to grant legal status to same-sex marriages. He said the Constitutional Court, having been convinced about discrimination faced by LGBTQIA plus community, should have molded relief under Article 14. He said the majority judgment was per incuriam, as it did not hit the settled principle that in the face of discrimination, relief should be provided. He went on to argue that the same-sex marriage issue needed to be referred to a larger bench or 7 judges. Para. This drew objection from Solicitor General Tushar Mehta, who said this issue was unrelated to the interpretation of Article 39B, engaging the attention of the 9-judge bench. Stop.